Hello students, I welcome you all to lecture number 6 of Indian Partnership Act 1932 in the CA series. These classes are sponsored by Shijendra Axon and I am your mentor Shekhar Gehlot. We are on the last chapter of our Indian Partnership Act, and by this lecture we will be finishing our Indian Partnership Act series. Now we have discussed how a firm can be dissolved. Okay, we discussed various situations in which a firm could be dissolved by partners or by the court, and so other situations are there. Now we begin with consequences of dissolution. Okay, what legal consequences, what can happen upon dissolution of such firm? Okay, upon dissolution of such firm. You give it a look and then we'll begin with our discussion. It goes from section 45 to 55. Consequences of dissolution. Okay, we are talking about consequences of dissolution of firm, not partnership. Okay. Because dissolution of partnership means some change in partners, but consequence dissolution of firm means the whole firm, the whole partnership, all partners have broken out with each other. The whole firm has gone out. Consequent to the dissolution of partnership firm, the partners have certain rights and liabilities and are discussed. What are the rights and liabilities which are left upon such dissolution of the firm? Liability for acts of the partners done after dissolution. Okay. What happen if something is done after the dissolution of firm? Notwithstanding the dissolution of a firm, the partners continue to be liable as such to third parties for any act done by any of them which would have been an act of the firm if done before the dissolution, until public notice is given to the dissolution. So now, just like we discussed that when a partner retires, he has to give the notice of the dissolution. Okay, he has to give the notice of the dissolution. Similarly, when the firm has dissolved, okay, and partners have not given this notice of dissolution to the general public or the people who are dealing with the firm, and any partner roams around just like earlier days and he tells people that I am still the partner of the firm and firm is still going on, and he contracts liabilities, then all partners shall continue to be liable even after the dissolution of the firm if something like this happen, provided if they have given the notice of the dissolution of the firm, then the partner is going to be liable independently and other partners shall not share such liability with him. Provided that the estate of partner who dies or who is adjudicated an insolvent, or of a partner who, not having been known to the person dealing with the firm to be a partner, retires from the firm, is not liable under this section for the acts done after the date. Okay, that means someone who is died or become insolvent, or a partner who is not known to other people, usually a sleeping partner. Okay, sleeping partner is not required to give a notice. Okay, so these kind of partners are not required to give a notice, so they will not be bound. Okay, these people will not be bound. Section 45 has two-fold objectives. What is Section 45? Section 45 is liability for acts done even after dissolution of partnerships. What are two-fold objectives? Let us see the first object. It seeks to protect third parties dealing with the firm who had no notice prior to dissolution. Okay, it is trying to protect the third party with which one partner of the firm has dealt, expressing himself as the partner of the firm and that the firm is still continuing. Okay, by showing that he has continued with the business relationship with them. So this section is trying to protect them, okay, from such kind of fraud. It also seeks to protect partners of a dissolved firm from liability towards the third parties. It says if the partners have given the notice of dissolution of the firm, so they will not incur any third party liability because of the misdeeds of any one of those partners who's just now still trying to take undue advantage in the name of the firm. Okay. Example: X and Y, who carried on business in partnership for several years, executed on December 1 a deed dissolving the partnership from the date, but failed to give a public notice of dissolution. On December 20, X borrowed in firm's name a certain sum of money from R, who was ignorant of the dissolution. In such a case, Y also would be liable for the amount because no public notice is given. So, when no public notice is given, R is lending money to Y, thinking that there is a partnership firm and they are carrying on the business and they will be able to repay the money. But he does not know that firm has dissolved. So now it is the fault of X and Y both that they did not give the public notice. Now, because but the amount has been taken by X only, but even Y would be liable because he has failed in his duty to give a public notice for dissolution of the firm. However, however, there are exceptions to the rules stated in the above example. That is, even where notice of dissolution has not been given, there will be no liability for subsequent acts in case. These are the cases in which notice is not required. Even if no notice is given, no liability will transpond to the other partners. What are those cases? The estate of a deceased partner when someone has died. So when someone has died, we cannot expect him to give a notice. Okay. An insolvent partner, someone who has become insolvent because an insolvent person may not have the money to get a notice published in the newspaper. It is a costly affair. Okay, you have to give the notice to the general public, you have to get it published in the newspaper. So it will definitely include some money, and an insolvent partner is not supposed to have money with him. A dormant partner, that is a sleeping partner, because nobody knows of a sleeping partner. A sleeping partner never comes into picture, so people are not dealing with the firm just because of the sleeping partner. In fact, they are not at all aware about the sleeping partner. Sleeping partner has zero reputation. Okay, so sleeping partner does not need to give a notice in such cases. Right of partners to have business wound up after dissolution. Section 46. On the dissolution of a firm, every partner or his representative is entitled, as against all other partners or their representatives, to have the property of the firm applied in payment of the debts and liabilities of the firm, and to have the surplus distributed among the partners or their representatives according to their rights. Okay. So it is the right of every partner to see that once the firm is dissolved, then the property of the firm is sold out for repayment of the debts which the firm had taken during its continuation, and whatever is left should be distributed between the partners as per their share and their rights. Okay, this is the right of the partners to see that it should happen. If it doesn't happen, they can go to the court as well. Because it's a right. Whenever you have a right, then you can go to the court for its enforcement if it is not being fulfilled otherwise. C. Continuing authority of partners for purpose of winding up. Okay. Continuing authority means authority will continue even after dissolution of the firm. The authority will continue. What authority will continue? Let us read. After the dissolution of firm, the authority of each partner to bind the firm and the other mutual rights and obligations of the partners continue notwithstanding the dissolution, so far as may be necessary to wind up the affairs of the firm and to complete transactions begun but unfinished at the time of dissolution, but not otherwise. That means they will have a continued authority even after the dissolution of the firm and even after they have given a public notice. Now say A, B, C, D, E partners in a firm. Okay, firm A, B, C, D is firm, and A, B, C, D, E are all partners as well. They enter into contract. They enter into contract to supply 40 tons. 40 tons of oil to X. Okay, in December 2020. In July 2020, the firm is dissolved. The firm is dissolved. However, despite the dissolution of firm, because this contract is pending, the partners could still purchase the oil and supply it. Okay, the partners authority will still continue till the time any contract which is pending, it has to be fulfilled. All partners shall be liable to fulfill the contract, as well as they'll have the right and they'll have the authority to bind the firm for completion of the contract. If now other partners are not interested, A alone is interested in fulfilling the contract. A buys the oil in the name of the firm and supplies it to X. Now other partners B, C, D, E and B, C, D, E cannot say that A has done the act after giving the public notice, then only A should pay for the oil. No, A will not pay for the oil alone. Whole firm is liable even after dissolution and even after the public notice. Why? Because this was the contract which was entered when the firm was functional. So this is a unfinished business, and firm has to be wound up. That means all business which is unfinished have to be finished. Okay, provided that firm is in no case bound by the acts of a partner who has been adjudicated insolvent. But this proviso does not affect the liability of any person who has, after the adjudication, represented himself or knowingly permitted himself to be represented as a partner of the insolvent. Okay, that means insolvent person, whatever he does, okay, he will not be able to, he will not bind the firm. But in any case, if someone becomes a partner of an insolvent person by holding out, represented himself or knowingly permitted himself to be represented as a partner of insolvent, that means he has become a partner of an insolvent person by holding out. An insolvent person is trying to cheat someone, then this insolvent person and this person who has become a partner of insolvent person by holding out, or partner by estoppel, then they two are, both will be liable, he will be liable. Okay, settlement of partnership accounts, section 48. In settling the accounts of firm after dissolution, the following rules, subject to the agreement of the partners, be observed. These are the rules which have to be fulfilled, or which have to be followed for settling the accounts of partnership firm. Okay, what are these rules? Losses including deficiencies of capital. If some loss you have suffered, or and deficiencies of capital, you do not have, the firm does not have enough cash, shall be paid first out of profits. Okay, so out of profits, first of all you will have to make payments to whatever losses. Okay, next out of capital, and lastly, if necessary, by the partners individual in the proportion in which they were entitled to share profits. So this is a rule in which the assets have to be distributed of the firm. First, how you will pay the losses of the firm upon dissolution. First, first charge shall be on profits. First of all, your profits shall be used in order to pay any losses. If you are able to pay your losses from your profits only, that's a good thing. But if you are not able to, if your profits are not sufficient enough to cover the losses, then the property of the firm, the property of the firm shall be utilized. That means every asset belonging to the firm will be sold in the market in order to pay the losses. Your profits are gone, and now whatever is left has to be paid by the property of the firm after selling the property of the firm. Now you have sold the property of the firm, still your losses are not paid. Then personal assets of the partners. Then you will sell the personal assets of the partner, and all the partners have become insolvent in repaying the loss, and still the loss is not repaid. Then that loss will be written off. Nobody is liable to pay that. Okay, so this is the order in which loss has to be paid. First of all, loss will be deducted from the profits, then property of the firm, and then the personal assets of the partner. The assets of the firm, including any sums contributed by the partners to make up deficiencies of capital, must be applied in the following manner and order. Asset of the firm. How the assets of the firm have to be used. Used or sold or etc. Including any sum contributed by the partners to make up deficiencies in capital. Suppose there was some requirement of funds, okay, and any partner paid those funds or gave those advanced loans to the firm. How do we deal with all this money? Paying in debt of the firm. First of all, debts to third party shall be discharged. That means first payment, when the firm upon dissolution will make the first payment, then the first payment shall be made to the third parties. Okay, first preference, the topmost preference will be the payment to the third parties. Now, when the payment to the third party is made, then after that you will, in paying to each partner rateably what is due to him from capital. Suppose some partner has given loan to the firm, then you will repay the loan of partners, if any at all. Okay. Then third one is, in paying to each partner rateably what is due to him on account of capital. Okay, what is due to him on account of capital? Repay the loan, and this is the loan. This is like initial contribution. Repay the initial contribution. Okay, in the capital he made, and now repay the loan whatever he paid him later on. The residue, in if any, shall be divided among the partners in the share profits. Whatever is left will be divided among partners. So this is how you have to this is how you have to repay the losses. First out of the profit, then after selling the property of the firm, then you will run against the personal assets. And this is how you have to utilize the assets of the firm. First of all, debts to the third party. Then for initial contribution, the partners. Then for the loan to the partners, then divide among the partners. It may be noted that prima facie Accounts between the partners shall be settled in the manner prescribed by the partnership agreement. The above mentioned rule applies subject to any agreement between parties. So, first of all, this order which we have just discussed is not final. Okay, it is always dependent upon the personal agreement between the parties. If there is no personal agreement, then this is going to be the rule. The above mentioned rules apply subject to any agreement between parties. The rules laid down in section 48 just specified as to what will be the mode of settlement of the accounts in the usual course of business. But if the partners, by their agreement, express any different intention as to the mode in which losses will have to be borne, eventually, or the manner in which capital or advances will have to be paid to any partner, such an intention must be given effect to. However, any such agreement cannot affect the right of the creditors of the firm. Okay, any such agreement cannot affect the right of the rights of the creditors of the firm. It is not they cannot have an agreement like that we will pay debts to a third party in the last. First we will divide among ourselves. Okay, or first we will pay to each other and then we will divide, and then if something is left then we will pay to the third party. No, this has to be always on the top. In these things they can arrange within themselves. They can arrange when they are making contribution paying to the partners and divided among themselves, then they can change this order, but this shall remain always on the first. And here when they are paying losses, they can say first of all we'll sell the assets of the partner, then we'll sell the profit firm's property, then we will go to the profits. They can do it anyway, but in any case they have to pay the losses. Okay, and they cannot take away the rights of the creditors by having an agreement. They have an agreement that we'll in the end pay the to the third party first, we will ourselves take it, and then they come to the court and say that act allows us that subject to the agreement. No, this cannot be the case. You cannot defeat the rights of the creditors by having an agreement of your own choice. The significance of the foregoing provisions is that if assets of the firm are not sufficient to pay off the liabilities of the firm, including the amount due to each partner on the account of capital, each partner would individually be liable to contribute towards the losses, including deficiencies of capital, in the proportion in which he is entitled to share profits. So, whatever proportion one is entitled to share his profits, in the same proportion he will have to contribute towards the sale of assets, okay, towards the share of losses. X and Y were partners sharing profits and losses equally. Okay, now X and Y are partners in a partnership firm. They were sharing profits and losses equally. That means 50-50 ratio is there. X has died now. Okay, suddenly. On taking partnership accounts, it transpired that he contributed 6,60,000 to the capital of the firm and Y only contributed 40,000. Okay, after his death, when the accounts were opened, it comes to knowledge that the 7 lakh rupees was the capital of the firm, and out of that 7 lakh, X had contributed 6,60,000 and Y made contribution of only 40,000. The assets amounted to 2 lakh. Okay, now the assets of the firm is of 2 lakh rupees. The deficiency, that is 6 lakh plus so and so minus 2 lakh, is 5 lakh. Okay, now the assets is 2 lakh rupees. So if you sell the firm will come to 2 lakh, give you 2 lakh rupees only. But the firm has to pay how much? Firm has to pay 7 lakh rupees to X and Y, because X and Y, X paid 6 lakh 60,000 to the firm and Y paid 40,000. That means they both paid 7 lakh rupees to the firm, and firm has an asset of 2 lakh rupees, and firm has to now pay 5 lakh rupees back. Okay. Now this deficiency, there is a deficiency of 5 lakh rupees, would have to be shared equally by X and Y's estate. That means now this Y will pay 5 lakh or 2.5 lakh rupees to X. Okay, sorry, nobody will have to pay anything to each other, they both will share. If in the above example the agreement provided that on dissolution the surplus assets would be divided between the partners according to their respective interest in the capital, and on the dissolution of the firm a deficiency of capital was found, then the assets would be divided between the partners in proportion to their capital, with the result that X's estate would be the main loser. Okay, because X has lost the main amount here. X has contributed the capital much larger than Y. Payment of firm debts and of separate debts. Payment of the debts of the firm and the separate debts. Okay, where there are joint debts due to the firm and also separate debts due from any partner. Okay, where there is a debt of the firm and debt owned by a partner, how that will be paid. The property of the firm shall be applied in its first instance in payment of debts of the firm. The property of the firm shall be applied firstly for the payment of the debts of the firm, and if there is any surplus, and after the selling of the property of the firm something is left, then the share of each partner shall be applied to the payment of his separate debts or paid to him. Then whatever share is going to the each partner, that share is going to be utilized for paying of the debt of that partner. Okay, paying of the debt of that partner. If that partner is still not able to pay, then other partner will have to pay. If they are not able to pay, then the property of all will go. Okay. The separate, because the debt of the partner is the debt of the firm. The separate property of any partner shall be applied first in the payment of his separate debts and surplus, if any, the payment of debts of the firm. Okay. If a separate partner has taken a debt and he is not able to pay, first of all, his separate property shall be sold. It is not that you will sell anyone else's property. First of all, you will sell his property. Okay. And then others' property will automatically come in if he is not able to pay the debts. Personal profits earned after dissolution. If you are making some personal profit after that dissolution of the firm, how will they be utilized? Where a firm is dissolved by the death of a partner, and the surviving partners or surviving partners along with the representatives of the deceased partner carry on the business of the firm. Okay, any personal profits by them before the firm is fully wound up must be accounted for by them to the other partners. Thus, a lease expiring on death of a partner, which is renewed by the surviving partners before final winding up, belongs to the partnership. Okay, so whatever there is a due, if the accounts are not settled, okay, if the accounts are not settled for a dead partner who has died, okay, or you are continuing the business even after dissolution of the firm in the firm's name. So, whatever profit you are making in the name of the firm, then you have to share it with the partners of the firm, or you have not paid the share to the dead partner, okay, and you are using his share, then you have to pay this share and the profits to his son or the family members. This section has to be read with section 53, which provides that in absence of an agreement to contrary, each partner or his representative is entitled to restrain other partners from carrying on similar business in the name of the firm or from using the property of the firm for their own benefit till the affairs of the firm are completely wound up. Okay, that means other partner can stop you from using the firm's name. But if you are using the firm's name even after dissolution, then whatever profit you are making, you have to distribute it with the partners. Return of premium on premature dissolution. According to section 51, in case of dissolution of partnership earlier than the period fixed for it, suppose the partnership was for 4 years or 5 years, but it dissolved on completion of 2 years. The partner paying the premium is entitled to the return of premium of such part thereof as may be reasonable. So, if someone has paid extra premium, just like in the case of X and Y earlier, we see X had paid 6,60,000, that is, he has paid a premium over this 40,000. Okay, he has paid a premium of 6,20,000. So, according to section 51, in case of dissolution of partnership earlier than the period fixed for it, the partner paying the premium is entitled to return of the premium of such part thereof as may be reasonable, regard being had to the terms of the agreement and to the length of the time during which he was a partner, except when partnership is dissolved. Okay, by death of one of the partners. Okay, in such cases, the premature dissolution will happen by death of one of the partners, mainly due to the misconduct of the partner paying the premium, pursuant to an agreement containing no provision for the return of the premium or any part thereof. Okay. So in these cases, the partnership will be dissolved and premium has to be paid. The partner paying the premium gets a proportionate part of the premium where the partnership is dissolved without the fault of either party. Okay. When without the fault of either party, the partnership is dissolved, then he will get a proportionate payment owing to the fault of both or due to the fault of both people, on account to the fault of the partner receiving premium or on the account of the fault of the other partner who has received the premium due to the insolvency of the partner receiving the premium. Okay, these are the issues. So in these cases, okay, in these cases, if a partner has paid a premium and the other partner has died, or there is a misconduct, the dissolution is due to the misconduct of the partner who has paid the premium. Okay, or when there is no provision in the agreement for return of the premium. In these three situations, you will pay him reasonably high than others, okay. But in these four cases, when there is no fault of either party, no fault of any partner, and the partnership is dissolved, firm is dissolved, or both are at fault, or on the account of fault of the other partner, or the insolvency of the other partner, in this case he will get a proportionate part. Proportionate part means if he had paid 40% extra, then whatever is left in the profits, he will take 40% extra. Okay, he will take 40% extra. If suppose X and Y two partners are there. Now Y contributed 1 lakh, he contributed 50,000. Upon sale, firm has assets of 70,000 only. Firm has assets of 70,000 only. Now he will get twice what he gets. Okay, because Y paid twice the amount X paid, so he will now get proportionate. That means he will get twice what X will get. So let us say X will get 25,000, Y will take this will come out to be somewhere at 22 to 22,500 something. Just you divide it, okay? He will get something like 48 and so on. 45,000. Something like this, okay? He'll get something like this. This is going to be the division. He'll get the proportionate share. Rights where partnership contract is rescinded or fraud or misrepresentation. Where the partnership contract rescinded means withdrawn or taken back or dropped, recalled. Okay, where the partnership contract is recalled due to fraud or misrepresentation, when someone has committed a fraud or misrepresentation. In such cases, what will happen? Where a contract creating partnership is rescinded on the ground of fraud or misrepresentation of any of the parties thereto, the party entitled to rescind is entitled. Now, the party entitled to rescind is entitled means X and Y enter into a contract. Now X comes to know Y committed a fraud. Now because Y has committed a fraud, Y does not have any right to withdraw from the contract because he is the party which has committed fraud. Only X has right to withdraw from the contract. X has right to resign the.
It's 4 o'clock.
Because we cannot honor or award someone who is guilty of committing a fraud. So we cannot give right to resign contract to someone who has committed a fraud. It will always go to the party who has received the fraud, who has suffered the fraud. So X has suffered the fraud. X has the right to resign the contract. Now X resigns the contract. Okay, the party entitled to resign entitled to resign is entitled. Now X is entitled. X is entitled to what? To a lien on the surplus or assets of the firm remaining after the debts of the firm have been paid, for any sum paid by him for the purchase of a share in the firm, and for any capital contributed by him. X is entitled to lien. Lien means to retain custody, like we discussed in the Sale of Goods Act. He'll have a custody of whatever is left after paying off. Okay. Custody of whatever is left after paying off. Okay. Not he'll not keep whatever is left, everything he will keep, but for his capital contribution. For his capital contribution. Okay, for his capital contribution. Whatever capital he had contributed, he will take that much amount back. To rank as a creditor of the firm in respect of any payment made by him towards the debt of the firm. So, if he has made some payments towards the debt of the firm because the firm was based on a fraud or sham, he will become a creditor of the firm. Firm will have to pay him back. Firm will have to pay back to him. Okay, he will be creditor. He will not be a partner because when he is a creditor, that means he will get a first preference. Okay, creditors get the first preference over partners. So in cases of in respect of those payments which he has made, suppose he has made a payment of 10,000 rupees. In relation to those 10,000, he will become a creditor and he will take this 10,000 first. But when he has paid 1 lakh as a partner, as a contribution, for this 1 lakh he will remain a partner only. But for this 10,000 which he has paid for the debts of the firm, he will become a creditor and he will get a first payment here. But in this case, he will not get the first payment. To an indemnity from the partners guilty of fraud, misrepresentation, again all debts of the firm. He will be indemnified from the frauds and misrepresentation of the partners against the firm. Okay, when partners have committed fraud and misrepresentation with other parties, third parties, and have contracted liabilities for the firm, then he shall not be liable for those liabilities. Only those people who have committed fraud shall be liable. He shall not be liable for it. Okay. Sale of goodwill after dissolution. Okay, now what will happen to the goodwill after the firm has dissolved? We discussed the case of Haldiram or Sarvana Bhav. Now, Sarvana Bhav is a firm. Suppose it is dissolving. What will happen to the goodwill? This brand name Sarvana Bhav, it itself carries a lot of weight, a great weight. All over India, it is very popular. Even in Delhi, there are so many Sarvana Bhav. At least 2, 3 I've seen. So, in settling the accounts of a firm after dissolution, the goodwill shall, now what will happen to the goodwill? Subject to the contract between the partners, be included in the assets. Goodwill shall be treated as an asset and it may be sold either separately or along with the property of the asset. You can either sell it separately or along with the property of the firm. Okay. Rights of buyers and sellers of goodwill. What are the rights of buyers and sellers of goodwill? Someone who will buy goodwill from you. Okay. and someone who's a seller of the goodwill, where the goodwill of the firm is sold after dissolution. A partner may carry on business competing with that of the buyer, and he may advertise such business, but subject to the agreement between him and buyer. He may not use the firm name, represent himself as carrying on the business of the firm, or solicit customs. Just like we discussed, when you have sold Savana Bhav, then you cannot use the name Sarvanabhav. Okay, you can do the competing business, but you can be restricted as well. Okay, agreement in restraint of trade. Any partner may, upon the sale of goodwill of the firm, make an agreement with the buyer that such partner will not carry on any business similar to that of the firm within a specified period or within specified local limits. And notwithstanding anything contained in Section 27 of the Indian Contract Act, such agreement shall be valid if restrictions imposed are reasonable. Like we discussed, if reasonable restrictions are imposed, such restrictions are going to be valid in the law. Okay, you cannot call that because this agreement is putting a lot of restrictions, so this is going to be against the public spirit and this is going to be against the law. So this kind of agreement is going to be a void agreement. Let's please give me a 2-3 minutes break. I'll be back. So, agreement and restraint of trade. Any partner may, upon the sale of goodwill of firm, make an agreement with the buyer that such partner will not carry on any business similar to that of the firm within a specific period or specific local limits, and notwithstanding anything contained in Section 27 of the Indian Contract Act, such agreement shall be valid if restrictions are imposed are reasonable. So, if you are going to impose a reasonable restriction after the sale of goodwill, okay, that within a limited territory you will not carry on a competing business. See, it does not make sense that I sold my burger business to someone, okay, and then in front of his shop only I set up another burger store. Now people know me, so they will automatically come to my shop and they are my old customers. I have their numbers. I will keep calling them and keep asking them to come to my shop. This is the new shop. I have changed my norm. I have changed the name of my shop. The earlier name I have sold to someone else. Now the people believe in me and my quality. I am the goodwill. Okay, not the name. Okay, but name will ultimately become the goodwill when I am compelled to leave the business. If I will not open the competing business, then people will automatically go to the name. Then the name will become a goodwill. But here my face is the goodwill. Okay, because I have set up a competing business in front of the earlier business. So now that cannot be done. Okay, reasonable restrictions could be there that yes, you go out of the state or or you go out of 300-400 kilometer territory and so on. Okay, goodwill is part of the assets of the firm, and section 55(1) enacts that in settling the accounts of firm after dissolution, the goodwill shall, subject to the contract between the partners, be included in the assets. Now it says that goodwill is part of the asset. Goodwill is just an asset of the firm. Like firm as an asset of chair, table, car, and property, like this. Goodwill, goodwill is like the brand name ABCD Limited. Okay, or sorry, ABCD firm. That ABCD, that name of the goodwill, that name of the firm is the goodwill. Haldiram Sarvanabhav. This name is the goodwill. So this name is part of the asset of the firm. This is the asset of the firm. And section 55(1) enacts that in settling the accounts of a firm, when you are settling the accounts of the firm, that means you are making a final settlement for the firm. You are selling the firm. Okay, your property of the firm is valued at rupees 2 lakh. Okay, then you will add value of the goodwill to it as well. Suppose goodwill is valued at 50,000 and your firm's property is 2 lakh, so your total account will be 2 lakh 50,000. The goodwill shall, subject to the contract between the partners. If there is a contract between the partner that one partner will retain the goodwill, okay, and goodwill shall not be sold, then you cannot sell the goodwill. Then the other partner will keep the goodwill with him and you can sell off the property. But if there is no such contract between the partners, then the goodwill has to be included in the assets and it may be sold either separately. Either you can sell it separately, that you will just sell the goodwill. You are not selling the whole business together to someone. You are selling your business in piecemeal manner. You are selling your goodwill separately. You are selling your assets of the firm separately. Okay, so you are doing everything separately. Or you can do one thing, you can sell your business altogether. That I have a car manufacturing business, my name is Tata. Like Tata purchased Jaguar Land Rover, the brand name as well as all the factories and machineries and the plants. Okay, when Tata purchased Jaguar and Land Rover from Ford, it not only purchased the brand name of Jaguar and Land Rover, but it also acquired all the factories, all the machineries, all the workers, whatever Jaguar Land Rover had, it all was purchased by the Tata. But Jaguar Land Rover could have done separately as well, that it could have sold the brand or the goodwill to Tata, that you keep the goodwill. From now onwards, you will manufacture Jaguar Land Rover goods, cars. Okay, but our factories we are selling off separately in the market. Our factories, our plants, our machineries. Okay, or Tata may say that I do not wish to buy your factories. You sell your factories separately. I will just buy Jaguar Land Rover brand. Tata could have said so. So, in those cases, you can definitely sell your goodwill separately, but ultimately, usually, what happens? Goodwill goes with the business. When you buy a goodwill, you buy the business as a whole. Okay, you just not you don't merely buy a name. Okay, so this is how usually it happens. The prima facie rule, therefore, is that the goodwill of the firm, being a part of the asset, has to be sold just like other assets before the accounts between the partners can be settled and the partnership can be wound up. It says that primary, the rule is that you will sell the goodwill along with the assets. Just like an asset, you will sell the goodwill before settling the accounts. There can be no settlement of the accounts without sale of the goodwill. If you want to, without the sale of the goodwill, if you want to settle the accounts of the firm, you have to sell the goodwill as well. Okay, then only the accounts could be finally settled. Mode of giving public notice. Now we have been discussing a lot about the public notice, that a retiring partner has to give a public notice, an active partner has to give a public notice, or if new partner has joined, they have to give a notice to the registrar. Okay, so what is that public notice and how do we? Mode means what is the mode? How do we give the public notice? Now, section 72 provides the mode of giving public notice. Let us read it. A public notice under this act is given. How it is given? Where it relates to the retirement or expulsion of a partner. Okay, when it relates to the retirement or expulsion of a partner, when some partner has retired or he has been expelled from a registered firm. Okay, from only a registered firm. That means unregistered firm, they can publish their public notice in other ways as well. From a registered firm or to the dissolution of a registered firm. Now, this notice is when you are retiring someone, or when you are expelling someone, or when your firm is dissolving. Okay, when your firm is dissolving, firm is being wound up, or to the election to become or not to become a partner. A minor also, on attaining majority within 6 months, he has to make an election whether he would become a partner in a registered firm or not. Okay, by a person attaining majority who was admitted as minor to the benefits of partnership, by a notice to registrar of firms under section 63. When some new partner has come, you have to give notice to the registrar, and by publication in the official gazette. Okay, so how you will give notice in these cases? Okay, in these cases you will give a notice. First of all, you will give a notice to the registrar of the firms. Okay, then publish you will get it published in the official gazette. Okay, official gazette of the government, you will get it published there. Then at least one vernacular means colloquial, local language. Suppose I am operating in Punjab, so vernacular is Punjabi. Tamil Nadu, vernacular is Malayalam. Okay, local language, local mother tongue, okay, in the district, and where the firm is, the firm to which it relates has its place of business. Okay, now how we have to give the notice we have to give in three type of notices. We have to give mode of notice, three notices we have to give. One, to the registrar of firms. Publication in official gazette. Then publication in vernacular newspaper of area in which place of business is. So now this is called a proper public notice. We discussed that notice has to be proper public notice. Now suppose you have given a notice to a registrar of firms and you have given the publication in vernacular, but you have not got it published in the official gazette. Your public notice shall remain improper, shall remain incomplete, and you will continue to remain binding. Okay, so you have to follow all these three steps In which case, in the case of a retirement or expulsion of a partner or dissolution of a firm or election to become or not to become a partner, in these cases, you will have to get the notice published in these manner. Right? You'll give a notice to registrar, then you will get official gazette publication, then you will get a publication in a vernacular newspaper. In any other case, by publication in the official gazette and in at least one vernacular newspaper circulating in the district where the firm to which it relates has place of business. Okay. In any other case, that means in the case of a unregistered firm. Okay, in the case of a firm which is non-registered, in that case you will not give the notice to the registrar of the firms. Why? Because your firm is not registered, so you definitely cannot give a notice to the registrar. And why will registrar accept a notice of firm which is not registered at all? Okay, then in that case you will get it published in official gazette and then vernacular in the district, vernacular newspaper which is circulating in the district where the firm to which it relates has its place or principal place of business. Then only your communication of communication to the public notice about communication to the public about your retirement or other events about your firm would be complete, and you can evade a liability successfully. Otherwise liability would keep running. With this we finish our Indian Partnership Act.